differences between a contractual and a property perspective on economic transactions. Let me explain what I mean by this difference. But I have been working and doing consultancy on the areas of property titling and business formalization for perhaps 20-something years. In this work, which was problem-driven, pragmatic, and with an emphasis on the organization or reorganization of existing institutions, I was missing the support of theory. There is plenty of law and economics. There is even a discipline, so-called economics of property rights, which honestly, right now, I came to think that it's not at all about property rights, but about contract rights, and as a consequence, cannot help us in this area. In fact, when collecting part of the essence of these papers for a book who came out in 2-3 years ago, I came to realize that there was an intrinsic deficiency in the literature which explains why policy in this area is, instead of being informed by lawyers and economists or people doing law and economics, is informed by surveyors, for instance. And in the case of land titling, the weight of surveyors is, the importance of surveyors is surprisingly very high. In fact, and those people from the World Bank here can illuminate us on this issue. The expenditure in these projects, for instance, is 70% is spent not in identifying legal problems, but in drawing maps, in geography, in essence. Well, I have been puzzled over several years by these issues, and I didn't have the opportunity when writing this book. I realized about the importance of the topic, the importance of the poor theoretical foundations of policy in this area, but I didn't have the time to go into this mostly theoretical issue. Therefore, when Claude Menard 2 years ago asked me to write a paper for a book on Ronald Coase, a book that has just came out a few months ago, I started to do some research on the theoretical biases that might have been causing this problem. In essence, and this is what I am presenting today is the consequence of this effort. In essence, my research question was to identify what are the roots, the theoretical roots, of the systematic failures I had been seeing in policy in this area. To advance the conclusion, I think the assumptions, in particular the assumptions in the classic paper by Coase on the problem of social cost, the assumptions which were useful for the purpose of Coase, which was the analysis of externalities, these assumptions have been extrapolated, have been misused. These assumptions, which are in essence contractual assumptions, have been extrapolated to property problems, and they are intrinsically inadequate for property problems, and that's why first the so-called theory of economic property rights had practically nothing to contribute to the problems of the organization of land titling, etc., or business formalization, but also to the extent that this has been the only economic or law and economics theory illuminating these problems, this field, it has supported as I said, systematic blunders in policy. Therefore, my effort is to connect these roots, these theoretical roots, with these policy failures. I don't need to explain you the essence of COS 1960, but as you know, the problem is one of two parties bargaining and through contract eliminating externalities. These are a particular type of externalities related to the use of assets. The typical example is pollution. You have a neighbor, a polluter, they negotiate, etc. Well, there is, as a consequence, a particular role for the state. The state here has a role in reducing transaction costs. Particularly, judges may have a role in enforcing performance. Also, the state may have a role in the initial allocation of property rights. And if transaction costs are very high, judges may have also a role in improving on the final allocation. Well, the punchline in cost analysis is that freedom of contract will help solving the externality problem. Therefore, the role of the state is directed to make that possible. Well, there is a hidden assumption here when we look at the problem from a property perspective. The hidden assumption is very simple, is that there are only two parties and one contract. And as a consequence, there is not even the possibility of finding interactions between contracts. A property problem, as scholars in property law perfectly know, a property problem has this type, at minimum, this type of a structure in which there are at least three parties and at least two contracts, and crucially, these two contracts interact, affect each other. In this case, this example is just a pollution example, quotient example in which you have a neighbor, you have a property owner who is also a polluter, but this property owner may contract with a buyer of the land. Well, is obviously, in this case, the problem turns out to be more complex, and the key question, which is a legal question, but also an economic question of tremendous importance, because it defines enforceability. The question is, this person B, who is buying in moment 2, what is this person buying? What is this person purchasing? Is this person purchasing in rem or in persona? Is this person purchasing a right good against the world, against everybody, including N? Or instead, is this person buying only an impersonal right, a claim, a mere claim, against just the seller? Well, obviously, this defines enforcement, the type of right, and also defines value, which, in parentheses, makes impossible to separate legal rights and economic rights. The question then changes in a crucial dimension. Freedom of contracting between the parties may substantially increase transaction costs. Freedom of contract means not only being free to drafting the contract. Strictly speaking, freedom of contract means also choosing which type of right, choosing which type of enforceability you are selling. In other words, to make an obvious example, if two parties are free to contract at moment 1 in secret, obviously this secrecy will affect the willingness of potential Bs to purchase at moment 2. Imagine that we are talking about externalities or rights to pollute, but imagine historically the most important example, which is that of collateralized debt, mortgages. Imagine that parties, the legal system, allows, as most legal systems have allowed in the past, to burden land with hidden mortgages. I mean, the typical problem in the ancien regime in Europe, and also the typical problem in many developing countries right now, in fact. In this case, obviously, the second transaction is hindered. I mean, transaction costs at moment 2 are increased because there is an increasing in information asymmetry between buyers and sellers. And this,
5 minutes.
5 minutes, okay. And this happens not only for the asset at hand, it happens for all assets. Because in principle, you don't know if that asset is burdened with hidden mortgages. Therefore, freedom of contracting increases transaction costs, or may increase transaction costs. This changes drastically, expands drastically the role of the state, the role of public ordering. Remember that in COS, this was impossible simply because there was only one contract. Disregarding these effects, disregarding what I am calling sequential exchange, I mean, the effect in transaction costs of having interaction between contracts, will make public ordering more necessary, or will make necessary a different type of public ordering. Consequences. Well, first, and this is widely recognized, first, the state will introduce, or some public agency will introduce more mandatory rules. Defining, in essence, defining in-rem enforcement. As this is widely recognized, I don't need to go into details in this aspect. There are other 3 aspects which are not so widely recognized. First, and these are connected to the quotient perspective. First, we're accustomed to think that the initial allocation is important. However, when we understand rise in rent, it's not only initial allocation that matters. After each transaction, we need some element of public reallocation of rights. Therefore, the issue becomes recurrent. Second, as I mentioned before, there is no separation between economic and legal rights. Legal rights are the main source of economic rights, the main determinant of economic rights, because having enforcement in rent determines a major part of value. Third, given that, intuitively, given that there are at least 3 parties, the scope of impartiality is substantially expanded. Therefore, it is not only parties, 2 parties to a single contract. This problem is relatively easy. This can be solved by arbitration. This can be solved by competition itself. But when there is interaction between contracts, you have a wider scope of impartiality needed. I suspect that this is a key element in all discussions about between formal and informal solutions in law. These 3 elements, and I will go very briefly now, these 3 elements, these 3 theoretical roots are behind policy blunders in this area. Say it very briefly. I mean, focus on initial allocation. Think about the prevalence of universal titling in land titling. Everything is about initially allocated everything very well. But second transactions are never registered. There is nothing is worried about what happens in the future, what happens later. The paradigm of this in terms of measurement is the doing business project. Doing business indicators, which are valuable in some respects, in some others are totally misleading because they consider only the initial cost of formalization and titling. Second, missing legal knowledge. The legal dimension is missed, and registries, for instance, are encouraged to prioritize quantity and speed and no legal quality. This is a natural consequence of this economic view that forgets about the value of the law. This is also visible in the emphasis on what? On geography, on mapping. Mapping, the value of mapping, the value of defining boundaries is zero, exactly zero, if the legal boundaries are not well defined. And let me mention only the third element, given that I am running out of time. In terms of private ordering, I mean, mention only the foreclosure crisis here in the US, which is directly connected to overemphasizing private ordering. But also in Europe, the reforms led by the European Commission to rationalize this industry, this sector of land titling, is, in my opinion, misguided because it's introducing competition in the private ordering element, in this case notaries, without realizing that the key element is strengthening the public side. Lastly, the current buzz about blockchain goes in the same direction. I mean, the generalized notarization through technology. Okay, let me finish here. Thank you very much.
All right, thanks, Benito. And we should all be very grateful to Benito that he has done so much work in this. Let's see if I can actually talk and open up at the same time here. Has done work in an area that, oops, those shouldn't have showed up yet. There's arrows coming in there, by the way. An area that many of us would find difficult to spend, to get in the details of land title registries. And I say this as the daughter of a surveyor and who became director of land titles in my home province of Ontario, Canada. But it is critical, and this is a very important paper, and I really want to emphasize that. So let me just give you, I'm going to talk quite briefly about the what I think are the key takeaways here from what Benito's doing here, and then just pose some questions for maybe to get our discussion going. So the key thing that Benito is emphasizing here, and that is missing from the standard approach that focuses on the Cozian framework for the initial allocation of property rights, is that there are sequential transactions. I buy the land from Benito, or I buy rights from Benito, and there's future buyers, there's future interests that are implicated by our behavior. There's sequential transactions that generate exchange externalities, and he's emphasizing in particular the exchange externality of hidden rights. So if we have a transaction either buying the pollution rights or perhaps putting a lien on property, and that is the way we structure that, in particular the way in which it's available to others, has implications for future transactions, and that's what limits the Cozian private ordering framework. That's a really very, very important point. Benito's emphasizing there the value of in rem rights here for solving this for solving some of our transactional problems. And just for those who aren't lawyers in the room, just to emphasize, the in rem right is the one that travels with the land, as we say, so that if the purchase of the pollution rights by the neighbor, or excuse me, against the landowner, if that's in rem, it travels with the land, and that means all future owners of that property are bound in the same way by that initial transaction, as opposed to only having claims in personam against the particular individual that then disappear as soon as the land changes ownership against that there. So that's a clear point that there's value to those in rem type of rights. And that, what he's emphasizing here is, for that you need a public third-party institution, a third-party institution that he's calling public ordering, so that it can't be resolved only by the transactors to decide what those rights will be and how they will be adjudicated. We need third-party institutions, and in particular, we need third-party institutions in order to oversee a set of mandatory rules, and importantly, that those mandatory rules require publication of the rights that were transacted at one point in time, so that future transactors are aware. So if you purchase the land, why do you do the land title search? You do the land title search in order to determine whether there are rights that neighbors have, lenders have, and so on, that are traveling with that land you're purchasing. And for that, you need publicity and a mandatory system of publicity, not just voluntary publicity or publicity chosen by the transactors. Secondly, you need impartiality in the decision makers who adjudicate disputes about those rights that goes beyond just the initial transactors. So if you're thinking about your Cozian framework and you have the dispute over rights to pollute, or you have a creditor and a borrower, you need they can't be the ones who are choosing the adjudicator, because that adjudicator has to be impartial also with respect to unknown future people who become involved with the land. And that's, I think, a very important point about the need for public ordering. So I just wanted to raise a couple of questions here about thinking about the public ordering piece of this. Of course, again, and this is just repeating a bit of the theme from our the earlier part of this panel that we're emphasizing, is that we could think of that as government, and a few times Benito says it's about the role for the state in creating rules, and want to emphasize, well, what we're really talking about here is third-party institutions, public institutions, and in the context that we're here to discuss of building legal order around the world, I think it's really important to emphasize that what we have to deal with in this context is the potential for corruption, and just corruption both in the bribery sense, but also corruption just in the sense as a system gets corrupted by the failure to do what it's supposed to do, bugs in the system, that it's not going to be executed if you have a weak or a poor government. And therefore, I think one of the things that I see coming onto the table from the work that Benito is doing is thinking about what are the alternative ways of thinking about the design of third-party institutions that could perform these two critical roles of mandatory publication and impartial adjudication of rights in assets. What are the other ways of doing that? So I've put up three thoughts here. One is the idea that third-party governments could perform this type of function. So here we're thinking about something along the lines that Paul Romer and Charter Cities has been thinking about, with the idea you could have a third-party host government that's actually adjudicating some decisions. We could be thinking about profit or nonprofit global registration providers that are globally regulated and therefore available to the governments in poorer settings. And Benito mentioned this. I wanted to put this up here as well because I think this is a tremendously exciting development with blockchain. So what is blockchain? Blockchain is a great spreadsheet, ledger in the sky, in the cloud, publicly accessible to all, in which ownership of assets is registered in that publicly accessible spreadsheet, and you have the capacity to affect transactions through that process. So if that system is being recognized, and Benito's mentioned it, we haven't actually talked about this, it just ended up on both his slides. I don't know if it's in the paper, Benito, blockchain. Is it in the paper? No, it's not. So I think it's actually a really fascinating way to be thinking about where some of these solutions to this really important problem might go. So we'll open it up we've got about 15 minutes for questions. Tom.
So first of all, Benito, I just want to say I always appreciate your perspective. It's important, I think, kind of if I can caricature a European counterbalance to the American obsession with private ordering and such, and very healthy to call these things into question. At the same time, I was sort of wondering in terms of the framing of the paper, if Coase could come back to life, I'm not sure you disagree with anything you've said. I mean, this is just another form of transaction cost, and in rem is a perfectly acceptable kind of solution that one could adopt, right? So I guess I was wondering why you were framing it as, why you were attacking Coase himself so harshly. And the second thing I wanted to ask is I'm not sure I understood why you said that foreclosure is related to private ordering in the United States. I think, you know, to give you one example, Detroit today is facing a massive foreclosure crisis, which actually is caused by the government's failure to reassess the tax rates, given that the property has declined. So I guess I see foreclosure crisis as being caused by some mix, at least, of public and private ordering to defend the American system a little bit.
Well, thank you very much for the comments. Today is a very important question about in practice, how to organize the state, quote unquote, how to organize this third-party intervention. I couldn't agree more. In fact, in the paper I tried to somehow hedge the language in terms of the state, of public ordering. I would say that I would like, at least, to define public intervention, or define the state on the basis of the problem. I mean, we need a different type of public intervention. We can call it the state or something else, but it has to respect certain patterns. Fourth, I think, it has to be impartial to the whole market. And the whole market often is the same as the whole jurisdiction. In practical problems, this is the main issue, because constantly parties have a tendency to be myopic and to want the public intervention to be impartial only with respect to themselves, without paying attention to third parties. Until the point they realize that in the future they will also be third parties. Therefore, this interaction is crucial. The consequence, the main practical consequence tends to be free choice of this third party. Parties can now be free to choose. Therefore, they are free to decide, in essence, when they will enjoy ingredient for non-life. I think this is but we can call it state, or we can call it private arrangement, or private ordering. But my way of thinking about this is, well, if there is a so-called private ordering, which is playing this function, well, this is not private ordering, because I will try to redefine private ordering as contractual and public ordering as property. When there are third-party effects, we have public ordering. On the other hand, about organizational issues, about how to organize, how to motivate these public elements, I am totally sympathetic to private structures, but without freedom to choose by those who are contracting. Second, on the issue of cost, I couldn't agree more. And in fact, the paper maybe not so explicitly, maybe it should be more explicit, but the paper claims that this is a purely coercion, respectful to the spirit in cost. What has been not respectful of the spirit in cost has been the development of so-called economies of property rights, which is, in essence, is not coercion in this methodological spirit. Finally, about the foreclosure crisis. Well, the private ordering element in the foreclosure crisis in the US is caused, is triggered by a private institution called MERS, Mortgage Electronic Registration Systems, which is a private registry created by mortgage lenders in the 90s, and it's a purely private arrangement, which has been, at the end, show itself incompetent, and judges in the US have decided, in a way, not to pay attention, not to pay enough attention not to consider any public effect of this private registry. This is only in connection to this. Obviously, the foreclosure in the US and everywhere is badly affected by the fact that it's a heavily political issue, and the states everywhere in terms of prices tend to fail, and so on and so forth. But my interest in this issue is particularly with this very American institution, which was supposedly to work very well because it was working very fast. But it's a paradigm case. It worked very fast, but it produced garbage in, garbage out. And at the end, judges themselves, for good or for bad, had not paid any attention to the information produced by this private registry because it's private, because it's partial. I mean, it's run by lenders, and therefore judges everywhere in the US end up saying, well, this is, we are paying attention to what is in the public record, not in this private registry in Virginia. Therefore, I mean, there is an important lesson here about the limits of private ordering, which is, in this case, it was working very badly. Organizational disaster with robo-signing and all these issues. But even without considering that, if there is a limit in private ordering, if you are going to have public judges, it is judges who decide if private ordering is going to have legal effects or not.
Yes. Hi, I'm Anita Ramasasri from the University of Washington Law School, and thank you very much for your presentation and paper. I deal with property and land rights as in terms of both issues of fraudulent conveyancing and also the issue of challenges by communities to land that has been acquired, they believe, either illegally or in contravention of certain principles. So as I was thinking about the issue of publication and the importance of notice, I guess my question to you is, notice only goes so far if you can't see behind the notice to the beneficial owner. So and that is in the United States, but also in many parts of the world now, the larger challenge, right, is that notice doesn't get to you who is the true owner that you need to challenge to vindicate your rights. So I guess it's just a real question for you is how do we deal with that piece of the protection of the property interest? And a question that I think Jillian mentioned with blockchain made me think about, which is that as you think about extending your solution and looking at institutions, is identity management itself also an essential piece of whatever you want to do? And then in the discussion you're having with Tom on the issue of the foreclosure crisis, I think you're right in saying MERS is a large trigger. I do, just point of information, in the US, we're now looking at, of course, the mortgage crisis is both about the property and the loan, but at least in the United States, it was also about the note, right? That the piece of paper was a separate set of interests and rights, and the absence of finding the note really led to many, many problems. So we're actually contemplating now a mortgage note registry. And that debate is very much alive. Should the states control it, the Federal Reserve, or should it again be back to the privatized market? So again, just your thoughts on do we need another type of registry and who should control it?
Well, tough question, especially this last one. I mean, I wouldn't dare to provide institutional advice to Americans, especially in the US. But yes. I mean, to say it briefly, we Europeans are often puzzled by how naive you Americans are considering your institutions. I mean, this proud that Americans have about their institutions is unwarranted in many cases. No? And this, I understand that coming from Europe and coming from Spain, especially, that the Spanish institutions have bad fame and so on. But that's my opinion. I should be sincere and telling you this. In particular in this area, in the area of property registration, and also company registration, the solutions in the US, the institutions are also in patent law. I mean, the US PTO is clearly improvable. I
I don't know if a federal, a centralized system, given that there is an insight here. The market is national. If you have, there is a need to build a correspondence between the size of the market and the size of the institution. And this is important also for the informal, formal solutions. I mean, informal solutions are very nice for local markets, but if the market is going to grow, you need a more.
It is, it's just that the counterpart to MERS
Therefore
is,
here,
yeah.
the American market is national. And you have a proof of this is the development of title insurance, how title insurance grew when the mortgage market grew, no? After the World War II.
Oh, yeah, my only curiosity is the counterpoint to MERS is that in the area, if we move from the land to the paper, that DTC, depository trust, and the idea of a privatized registration of shares has actually worked very well. I mean,
No.
the regulators stand, so it's just, I think we're having that debate.
No, in the paper I analyzed MERS,
Yeah.
and MERS could have worked, but the question, and this goes also for Gillian's point, I mean, I think the key here are hybrid solutions, because we know that public administration is very inefficient. Therefore, the general question is, when do we need the essence of public intervention? I mean, the liberal state, liberal in the sense, in the classical liberal, in the 19th century sense, this minimum public institutions, what are its minimalistic functions? And then we can organize them with private incentives, but respecting these elements of impartiality and so on. For instance, MERS, the way it was organized, I mean, lenders registered on a voluntary basis. Therefore, they didn't know who was the lender of last resort, because they didn't have an incentive to register in many cases. This, just to mention a key point. Another key point, the bureaucratic procedures minimum standard of quality needs to be ensured in the bureaucratic procedures. These people were simply missing information. Therefore, you need a minimum of regulation, very simple, but that minimum to be respected.
Yeah. My harder question, and we can talk about during the break since others have questions, is really this issue of if there is notice in publication, but a shell company is really what has registered and owns the property. To me, it doesn't really, it's just not advancing sort of any kind of larger institutional. So I guess the question is, what does one do? Because
And I think with the hard question of what does one do, we're going to have to break there and transfer over. But thanks very much, Benito. It's terrific.